Good afternoon. It's 2 o'clock, so I think it's about time we got started. Thank you for joining us for our latest webinar. This is on the Mental Capacity Act and Home First Hospital Discharge. You've got me and Sandy today, and we're going to go through a very brief review or look at Home First, but then really concentrate on how the Mental Capacity Act interacts with that. So just before I really get going, just look at the housekeeping. If you could sign out of Skype if you haven't already, that's really useful, just because sometimes it interferes with the Teams events. You can't comment or make rude signs at us because we can't see you or hear you, but please do get involved and use the question bar. And there's a helpful little symbol if you haven't found that already. Hopefully you're familiar with that. Please ask any questions or comments or things that we're not sure about. We will do our best to monitor those as we go through and respond to them. And hopefully there'll be a little bit of time at the end, if I don't talk too much, to answer those questions. If we either run out of time or you ask questions that we don't know the answers to, we will find out and we will post those out along with the evaluation forms. So just a warning though, that if you are going to make comments, this session is being recorded, so please don't swear even if it is in writing. And at the end we will send out the evaluation forms, and once you fill that in and send it back, which is really helpful to us so that we can try and produce future presentations that address the sorts of things that you want us to, and do it even better than we will do today. And once you've done that, you'll get your certificate to say that you've attended. So as I said, have a quick look at the Home First model, look at where the Mental Capacity Act fits in, and that will include sort of going over assessing capacity and best interest decisions and where they fit into that speedier discharge from hospital. A bit of case law to help us look at what we mean by assessing capacity and what we're considering, and then a quick look at what we do with objections and the Court of Protections. You probably know, or a lot of you will know Home First better than I do, because I know the theory of it, and from the outside a lot of you are actually involved in putting it into practice. But it has focused the emphasis on discharge from hospital as soon as possible. So as soon as the patient no longer meets the requirements for being in hospital, the emphasis is very much on discharging home where possible, but discharging from hospital as soon as the patient no longer needs to be there. And the ward refers to the single point of access, as you know, and the single point of access, apart from pathway 0, decides on the pathway, the discharge arrangements, and the up to 6-week joint funding. There'll then be a case manager appointed based in one of the clusters, and then the assessment should take place within that up to 6-week period, with the progress tracked by the single point of access. And as for where the Mental Capacity Act fits in, it's just to emphasise that there has been no change to the Mental Capacity Act, deprivation of liberty safeguards, or the Court of Protection. So I even managed to put it in capitals. So just to emphasise the fact there has been no change to the MCA. So even if patient choice is limited by the new arrangements, even if the emphasis is on speedy discharges, the patient must either still consent to the discharge if they've got capacity, or a best interest decision is required if they lack capacity. And if they lack capacity, that means somebody has done an assessment that shows they lack capacity. So the very starting point of where we're coming from is, yes, there is a new system for discharging people from hospital. Yes, that emphasises the need to move on at pace and discharge people. And it might mean that the choices that people have are more limited than they might have been previously, but there still has been no change to the Mental Capacity Act. That's my quick introduction. I'll hand over to Sandy to take us through the next stage. Thank you.
Thank you, Paul. Good afternoon, everybody. So the Mental Capacity Act legislation provides a clear framework to support clinicians and social workers when assessing mental capacity. However, defining and judging capacity often requires that fine balance between maintaining a person's autonomy and protecting a vulnerable adult. So establishing a mental capacity consists of a two-stage approach. First, the need to establish that the person has an impairment in the functioning of the mind or brain. And secondly, that impairment is sufficient to prevent the person from being able to make a decision at the time that the decision needs to be made. It doesn't matter if it's temporary or permanent, although we know that some people will regain capacity after a short time in hospital. However, when thinking about the functional tests for capacity, if understanding, recall, weighing up and expressing choices are not reliably probed and assessed, practitioners may decide, for example, that a person has capacity, so that capacity is present, because the person either just agrees with our professional decisions or our discharge plan, or they may just say yes when they're asked if they understand. So superficial or snapshot assessments are likely to be inaccurate and therefore might miss both people lacking capacity and those who with support, such as simplified information, could achieve capacity. Some studies have suggested that clinicians often equate treatment refusal with a lack of capacity and treatment or agreement to a care plan or as acceptance of competency. So we do have to take our time and make sure that we really are sure about capacity. It's important also to remember that capacity assessment's not just a memory test. So a person's emotions, their personal values and experiences are equally valid factors alongside their level of cognition and contribute to their decision-making ability. When I'm completing best interest assessments, relatives often say to me, well, how can my family member make a decision because or make a choice because they lack capacity? And it's been suggested that expression of choice is less cognitively demanding than other aspects of decision making. And also when thinking about mental capacity, just to remind you of principle 3, that unwise decision making doesn't in itself determine that a person lacks capacity to make a particular decision. Let me just go back. Get to the right slide in a minute. Right. I think also it's important to think about principle 2, and that reminds us that all practicable steps should be taken to support the person to make a decision. And how would that work in a hospital ward setting? So in your busy hospital ward, we know it's a busy environment. How does that work? You might like to write down your thoughts in the question bar at the side, and we can either discuss them or we'll try and respond to them. I'll just give you a couple of seconds to think about that. So what would you do to support the person? What practicable steps would you take to support the person to make a decision? So I'll move on. Hopefully you might have had a chance to just put a few thoughts down. So I would say that the same issues would apply in any care setting. It's important to think about ways to optimise capacity, so including conducting the assessment at the best time of day for that person. So perhaps not in the evening when their cognition might be worse or they might be more disorientated. Encourage the person to engage by making them feel at ease. And I know it's often difficult in a busy hospital ward, but if possible, you are able to find somewhere quieter for them. That often helps. Can a family member or carer who knows the person well support them and reassure them through the process? And it's important to make every effort to communicate with the person in order to explain what's happening. Make sure that you present any information in the correct format for that person in a way that makes it easier for them to understand. and involve others as soon as possible. So if you have a person who doesn't have any family to consult, think about that. And if you need an MCA referral, think about doing that as quickly as you can. Involve again, as quickly as possible, the speech and language team or occupational therapist to help for support with communication and communication aids. And make sure that the person has the right information about all of the potential available options for them. So what's most important in the process is thinking about your time with the person. And again, I know in a busy ward setting that's really difficult, but actually it's really important to get this right. So frontline staff who are likely first contact with a person and patient, you're likely to be clinicians, you're going to be key in obtaining information as early as possible in the process. And relevant information will include the person's previous care journey, recent events, and information from consultation with the person themselves and with others. If the person lacks capacity to make decisions about their discharge, then any decision made for them will be in their best interest. And again, as Paul said earlier, the home first discharge process doesn't alter this. There remains a statutory obligation to consult with both the person and anyone interested in caring for them or involved in their welfare, and it must be a meaningful process, and sometimes that might take time. Lord Justice Mumby clearly reminds us that it's an unacceptable and actionable breach of a person's Article 8 rights under the European Convention of Human Rights to merely make a decision about a person without reference to the person themselves or their carers, as this is fundamental to treating them as a human being. So when thinking about best interest decision making, you need to consider, is there an attorney or a court of protection deputy who can make that decision on behalf of the person or the patient? It's important to consult with all of those with an interest in the welfare of the patient. And often that might be a friend that they've known for years and years. And quite often we've come across cases recently where it often is a friend. Starting with the patient's wishes and feelings. So again, that almost should be your starting point. The courts take that really seriously nowadays. So start with the patient's wishes and feelings and consider all information and opinions gathered. And look at the pros and cons of each option and decide on the patient's best interest. Oops. I've got nothing. So the key to speedy discharge decision making for this group of patients is early identification and robust assessment. So it is important you take time. I'm going to pass you back to Paul now, and he's going to talk to you about some case law.
Thanks, Sandy. I just want to look at a couple of old cases that you might be familiar with, but I think they're really useful in this current discussion about looking at what are we considering when we're considering patients' capacity to make care and accommodation decisions for themselves. And I think sort of the seminal case goes back for sort of 7 years. There's 2 cases on here. It's the same person. He's a young man, you can tell how old I am because 29 is a young man, who was living in a supported living placement. He had a learning disability. I think he was assessed as having an IQ of 59, and it would generally been accepted that he lacked capacity for a lot of things, until it got to this sort of stage, and there was a long running dispute between the local council, who felt that this man would be better moving to an independent flat with a package of support tailored to his own needs rather than staying in the supported living placement. And his parents objected to this and felt that he ought to stay where he was. which is why it ended up in the Court of Protection, because they couldn't resolve that dispute. The judge asked for capacity assessments and had some from one from a psychiatrist and another from a social worker. And just as an aside, was interested in that the preferred assessments were ones that specifically, sorry, I'll put my teeth in a minute, specifically looked at the concrete situation for this individual. So looked at Kay and how Kay responded to things, rather than a general assessment of how people with learning disabilities might think or might behave. Interestingly, the second case was 5 months later, once those assessments had been done. And I am not for a minute suggesting that if somebody is in hospital, taking 5 months to get comprehensive capacity assessments is going to be appropriate or indeed possible. But I think the reason we're looking at it is because not only did it find that he had capacity to decide where he lived, but mostly because the judge set out what she considered to be the relevant information for this decision. And I think as a guide, it's really helpful to have this sort of almost a checklist to say, what are we looking for that we would expect somebody to be able to understand, to remember, to use and weigh, and then come to a conclusion about where they're going to be living. And she looked at the accommodation decision, and the things that Kay needed to know was what the options were. So it had to be explained to him, as Sandy said, in clear and in relevant ways, what the options that were available to him were. So it meant having a conversation with him, and in fact, maybe more than one conversation with him to outline what's possible. Needed to know what areas the two places were in broad terms, and any risks and benefits of one area rather than another. Needed to know the difference between visiting somewhere, going to have a look and going to visit somebody in a particular place, and the difference between that and living there. And in Kay's case, he knew what it was like to live in the supported living placement, but he had to be able to understand the difference between visiting the new place and actually going there permanently. He needed to know the activities available if living in either place. So what would be available in one place that might not be available if he was living in the other? And for most people, and certainly in Kay's case, the ease of seeing friends or family if living in either place, particularly if travel's involved. And in Dorset, as we know, what's public transport like if any friends or family are relying on that? What's the ease of seeing family and friends if living in one place rather than another? Also looking at the tenancy or license arrangements to see, which I'm not sure what's happened to the slides, but the tenancy agreements or license requirements in each place. So again, not necessarily knowing the details of what's in a tenancy or license agreement, but knowing what's expected of him if he was living in one place rather than another. Also, who we're going to be living with. Does he know who he's going to be sharing with? Does he know who his neighbours are going to be? Does he know the difference between living with people in one place or living with people in the other place? And in very broad terms, what care he would receive. So what is available if he was living where he was living then, and what would be available if he moved to his new place? In some ways, relatively straightforward information, but I think those are the sorts of things that are going to be applicable to most decisions around accommodation. The weight attached to them might vary depending on the circumstances. And the last bit of information that was particularly relevant to Kay, but may not be so relevant in other places, was that there was a risk that he might not see his father if he moved to the new flat. His dad had said that he wouldn't visit him if he decided to move to a different flat because he objected to the decision. Now, whether his dad was going to follow that through or wasn't, it's difficult to tell, but certainly at the time his father was saying that there was a risk that Kay may not be able to see him should he decide to move to the new flat. Judge also set out what wasn't relevant, so the cost of the placement. Now again, for Kay, that was absolutely irrelevant because the state was going to pay for the placement wherever he was. He was entitled to full payment of the accommodation where he was living at the time, and he would be entitled to full full payment for the placement if he moved. For other people, that might be a relevant piece of information. If I'm self-funding, for instance, that might be relevant, that I have an idea of what's happening. Although if there is somebody who's appointed to look after my money for me, then that may not be relevant. The value of money wouldn't be relevant. The legal nature of the tenancy agreement, as I said before, it would just be the requirements that would be imposed, but not necessarily the detail of what the tenancy, legal nature of the tenancy agreement involved. And the long-term relationship with his father, and the judge talked about 10 or 20 years time. So while the immediate consequences might be foreseeable, I think it's about not looking too far ahead and not because in 20 years time, who knows what any of us will be doing in 20 years time. So it's about what's reasonable and what can be predicted that the person needed to be able to understand and consider. And the judge made it really clear that we shouldn't set the bar too high. We shouldn't be expecting people who may lack capacity or where their capacity is questionable to understand to a greater degree than the rest of us need to. Also set out the capacity for care decisions, and often the two are interrelated, but the sorts of things that needed to be considered in this case, and I think can be extrapolated to the sorts of cases that we might be looking at when we're looking at discharges from hospital. And if someone has been discharged from hospital and we're looking at their longer term care plans, what sort of decisions, what sort of issues need to be understood in order for someone to have capacity for their care decisions. So what areas he needed support with, and the sort of support that he needs. He needed to know who would be providing him with support. And again, that's in the immediate future, not necessarily foreseeing long-term decisions, but if he moved, in this instance, moved to one living condition rather than another, who would be providing him with his support? He knew the people that currently provided him with support. He needed to know who would be doing that if he moved to the new place. He needed to know what would happen if he didn't have the support, either because it wasn't there or if he refused it, and what the consequences of that would be, again, in the sort of foreseeable future. What would the foreseeable consequences be of not having the support that was identified? And also he needed, which I think is quite interesting, he needed to know that carers might not always treat him properly, or they might not do things in the way that he liked. But if that happened, he could complain. He didn't have to just put up with whatever he was offered. And as an extension of that, he needed to know who he could complain to. And that would be part of his decision-making process. Again, what wouldn't be relevant in his case was the fact of how his care would be funded and the overarching arrangements for monitoring and appointing care staff. So he didn't need to know what the safeguarding procedures were. He didn't need to know about how agency staff might be appointed and who was overseeing that. He just needed to know who would be providing the care. Very much brought out the importance of using those tangible resources to help somebody understand as much as possible. So the importance of using drawings and pictures and clearly articulating the information relevant to the decision, as people have said before in the chat bar, about making sure people have all that information, but in a way that makes sense to them. In Kay's case, it was very much around taking time, a long time in his case, to be able to do that and to increase his ability to make his own decisions, to the point where the judge found that he had capacity to do so. Even though the timescales will be truncated for somebody in hospital, the decisions will need to be made quickly, but that doesn't negate the importance of being able to do everything that is possible to enable people to make their own decisions where they can. Interestingly, in Kay's case, although he was found to have capacity, the court's inherent jurisdiction was used to protect him because he was still extremely vulnerable. In some ways, what happened to Kay isn't the issue. The important bit is the setting out of the guidance around the sorts of issues we need to look at in any decision around whether someone's got capacity to decide where they live and whether they've got capacity to decide about the care they should have when they get there. The other case I just want to highlight, again, a very famous case, the KK case. An 82-year-old woman who had a range of difficulties, which left her vulnerable. She lived alone in a rented bungalow, dependent on others for her personal care, and was frequently calling both her call alarm and 999 up to dozens of times a day, which was very difficult for people to manage. She was then admitted to a care home because she had a UTI, and associated with that was dehydration, became unwell, moved into a care home, but then wanted to go home. And while there were a number of assessments by professionals that found that she lacked capacity to make the decision around her care and accommodation, Mr. Justice Baker found that she did have capacity and set out his reasons why he felt that the previous capacity assessments had been unreliable. And again, I think it's helpful when we're doing capacity assessments to take his comments into account. And he made it really clear again that we can't start off with a blank canvas. So again, it's about giving the person, KK in this instance, sufficient information about what's available. He felt that when she was given the two options, she was given the option of remaining in residential care with 24-hour care with people around her all the time, or going home without care. Well, actually, she was never going to go home without care because there was always going to be a care package put in place. So it's about what is available to the person and making sure that she has the information available so she can make the choices. I can't be expected to make a choice unless I know what I'm choosing between. In the same way as if we're doing a capacity assessment, we need to make sure that the person is aware of what they're choosing between. Again, emphasising that we don't set the bar too high. She only needed to understand the salient features, just the main points of what would happen if she went home and what would happen if she remained in the care home. As professionals, we need to avoid the protection imperative. The assessment of someone's capacity shouldn't be influenced by the decisions they're likely to make if we find that they do or don't have capacity. Very difficult to do in practice. If I'm worried that somebody is going to make a decision that's going to put them at significant risk, that is likely to influence my view of their capacity. It shouldn't do. And I think it's important that we avoid that protection imperative. On the other hand, the judge did say that we need to avoid the excessive sympathy for someone's wish to return home. It's between a rock and a hard place. I hesitate to say we can't win, but it is about just being really aware of what we're doing and why we're doing it, making sure we're not being overprotective, but also we're not being overly swayed because somebody's strong wish to return home means that we're sympathetic to that issue. Looking at the evidence, trying to tease out whether they understand, whether they can remember, whether they can use and weigh and come to a conclusion. And just one more sort of basic but worth repeating issue that he pointed out is that the onus is on us to prove a lack of capacity, not on the person to prove that she's got it. So again, we need to be setting out our evidence really clearly about why they can't meet the test for making their own decisions. We're having some technical problems at the moment about getting Sandy's microphone working, so I'm sorry about that, but hopefully we can sort that out fairly quickly. We're just going to then move on to looking at when patients are objecting when they lack capacity and what we need to be doing to address that.
And oh, lovely, right, my slides are in the wrong place too now. Yeah, if I can, the slides are in the wrong place. Right, whoops. Okay, sorry, I'm back and hopefully ready to go. One of the concerns about discharge delays is often when a person is objecting to their discharge plan. And so if a patient is objecting to the discharge plans indicated by the best interest decision, then additional authority is required in order to move them. This is likely to need an order given by the Court of Protection, and the quickest way to get a case heard by the Court of Protection is via an appeal against the dole's authorisation, so a Section 21A application. The key to avoiding delays to a discharge is an early identification of those patients who might need a dole's authorisation and who might object to their eventual discharge plan. And again, ward staff, you're key at this point again. The DOLS teams will then prioritise the referrals, as will Dorset Advocacy and the Court of Protection. So interim orders can be agreed quickly if the necessary information is to hand. And again, that still goes back to getting all of the right information in place as quickly as possible and robust assessment. In terms of the Court of Protection process, the representative under the DOLS, the deprivation of liberty safeguards, would apply to the Court of Protection on the patient's behalf. If everyone, obviously excluding the patient who's objecting, agrees that an interim move is appropriate, then the Court of Protection can agree this quickly. You need to have mechanisms in place to collect evidence to support the application for an interim move, particularly in connection with, again, a robust capacity assessment in respect to the person's care and accommodation, a best interest decision, including why going home isn't possible, an identified placement, and a transition plan which the judge will want to see before the person can be moved. I just want to spend a few minutes thinking about the dynamics of decision making and the impact on the person and their family. I recently found a qualitative study published in November 2019 by Cambridge Institute of Public Health, Cambridge University and the University of East Anglia. It included a cohort of 48 people who were aged over 75 and they were living in Cambridge. And it reflected some evidence that older adults are often not consulted as part of the decision-making process for transitions into care. And the language in the study talked about people being propelled by moral persuasion from health professionals, their family or the wider community. And I thought this was quite an interesting table because it shows really how these decisions are often a continuum. They're often made on a continuum between the person on the left hand column here being very self-motivated, being able to plan and make autonomous decisions, to the other end of the scale, where a move is imposed upon the person and they're moved into care, where a family often makes the decision without even consulting with them. So I thought this was quite a good little table, really. But again, if you want to have a look at it later, I have put the reference for the research at the slide at the end of the presentation. So again, just thinking about the person in the middle of it, really, how do we support the person to navigate the process? And again, that's thinking about that person in the middle there and the potential, if they've got positive choices, are they persuaded to move by other people? Are they able to make a rational alternative alongside family members and other people who have concerns about their care? Are their views discredited? And at the end of the day, is it a fait accompli for them? It's really important to think about how do we support the person into the process. The study describes situations where families are invoking the powers of health professionals and where some negotiations with family met with resistance and had to be revisited at fraught hospital bedsides and were subsequently scrutinised by social workers. So you don't want to be in that position where obviously you've got someone who's been in a health crisis There's a lot of stress, particularly for families around the situation. And then at the end of the day, the person in the middle of it has no say and isn't consulted with about the potential plans for their move. Although the study focused on older people predominantly with dementia, the main conclusions that came out of that report for me were to remind practitioners to support families to discuss moving and housing options at an early stage before health crises, and also make sure those discussions are recorded. So in doing that, you're going to optimise the person's potential participation in future decision making and potential best interest processes when they actually get to the point where they no longer have capacity. And it would speed up the process if we already know what that person's wishes are. So it's important also to be aware of unconscious bias and that mindset in the past, where people who are cognitively impaired are viewed as lacking the ability, the autonomy, and the right to make decisions about their long-term care. Section 2.3 of the Mental Capacity Act reminds us that a lack of capacity can't be established merely with reference to the person's age, their appearance, their behaviour, or a particular condition. And finally, it's equally important to remind practitioners, also highlighted in the research, of the importance of minimising the impact of moving and how traumatic that was for families came out of that report, really, and to be supporting their frail, vulnerable relatives through any kind of move in later life, particularly when the process is happening now at such a fast pace as we're obviously expecting with this discharge process from hospital now. So, as I said earlier, please let us know your thoughts about the presentation today, and I've put some of the research, the reference, sorry, for the research at the end of the presentation in a slide. I'm going to hand you back to Paul now, who's going to just...
Thank you. Just following on from what Sandy has said, we've had a couple of cases recently where, while the person needed to be in residential care, the method by which they got from hospital to residential care was significant in the way that they settled, or in both cases, how they didn't settle. And part of that was about agency and their feeling that there's something had been done to them without their involvement. And in fact, one of the two has moved from one care home to another. She was involved in, although she lacked capacity, she was involved in the discussions around moving to a different care home. And just the feeling that she was involved in the decision making, even though she still ended up in 24-hour care, made a huge difference to how she felt about it. And she settled and was, last time I heard, she was happy in the new care home. And that process and the impact of not feeling part of the decision making was really significant for that individual, and we've got a second person in a similar situation at the moment as well. And I think, given, as Sandy said, the increased speed of discharge, the increased necessity to make quick decisions, it's still important to say where we can, and to as much a greater degree as we can, involve the person as an agent to the greatest degree in decisions being made with them, as opposed to about them. I just wanted to look at some things that I found quite interesting that are sort of vaguely connected, but not necessarily. But I thought they were useful to just highlight to you. The first one was about the lockdown regulations and care home visits. I've had to change this. In fact, I changed it today because I see that things are changing quite quickly. The previous guidance that I was going to talk about was around the tier 2 and tier 3 restrictions, and where, although the government guidance was talking about local control and being guided by local public health guidance, it seemed to indicate that visits should be restricted to exceptional circumstances, such as end-of-life situations. However, they've now decided that there will be new guidance, given we have a national lockdown starting on Thursday, and we will have new guidance around care home visits before Thursday. Now, given we're Tuesday at the moment, hopefully that'll come out fairly quickly, and we will sort of highlight that where we can. Incidentally, Mr. Justice Hayden has sent out a memo recently saying that contact with residents living in a care home is lawful, and has emphasised the concerns that the Court of Protection has about the impact on, and they particularly look at elderly people, but I think by extrapolation it will apply to anybody in a care home who lacks capacity, but elderly people who lack capacity on the isolation that results from not being able to have contact with particularly family, but family and friends, and the general activities that they normally engage in, and has emphasised the fact that blanket bans on visiting are questionable at the very best. There needs to be a proper examination of the impact of stopping or restricting contact with family and friends on each individual. So it has to be a best interest decision. Now, many years ago, I was a care home manager. I wouldn't want to be making those decisions at the moment. I think it's a really difficult balance to get between protecting people who live in the care home and indeed people who work there, with the need to maintain contact wherever possible. So although I don't minimise the difficulty in making those decisions, it is essential that they are made on an individual case-by-case basis. And while they're not our decisions, it's the care homes that are making those. We can support them and be involved in those decisions when we're placing people and when we're managing people's expectations and when we're supporting people's family in those discussions with care homes about how best to maintain productive and positive contact with their relatives. The second case I put up there is a very recent case, and again, it's nothing to do with the subject we're talking about today, but I think it's particularly interesting and very helpful because it looks at coercive control in capacity assessment and best interest context. It involves a woman who was 60 who had been admitted to hospital 3 years ago under the Mental Health Act, but in a really parlous condition. She had been starved, been deprived of food by her partner, and the decision now was about whether she should be discharged from hospital back to her own home where he was still living. She wanted to return home with him. She wanted to maintain the relationship, but there were huge concerns around the level of coercive control. And eventually the court found that she lacked capacity because of the degree that the coercive control impacted on her mental health, and therefore her ability to use and weigh information in connection with her safety and her relationship in connection with that. And then the best interest decision was looking at protecting her while respecting her wishes to maintain a relationship, actually taking that out of her decision and making a decision in her best interest. What I think is particularly helpful when you look at that case is that I think it's a Justice Hayden one again, set out the sorts of almost a checklist that as workers we need to look at when we are considering relationships, and coercive control might be a factor in them. And it gives a really helpful, I think, list of things that might indicate that we need to look at things really closely, and would indicate that somebody is in a coercive environment, and how that might impact on their ability to make decisions. The last thing I wanted to just look at, I'm not going to look at it in any detail, but just to let people know that there is new guidance that's just come out from the General Medical Council about consent. It's aimed at doctors. The link is there, so you can look it up. It's got a very good section in there around people who may lack capacity and how doctors have a responsibility and how they might go about doing capacity assessments, making it very clear that it's not something that can be passed on necessarily, particularly when it's looking at capacity to make decisions around medical treatment and medical care, that's something that doctors need to take into account. And I think sometimes that can be really helpful in those situations where there's a debate around somebody's ability to consent to what treatment is being proposed. So it's just really to let people know that that's out there. It comes into effect this month, so it is very up to date. It's worth having a look at and being aware of. A couple of people have asked for the reference to the study that Sandy mentioned. It's there. It's worth having a look at if you're interested in just the impact that they were saying about the degree of control that people feel they have, even if they lack capacity, depending on their awareness of what's happening, just the impact it can have on people, how involved they are. That's all that we wanted to say. And usually when I'm involved, we've not taken up the full hour and possibly more than the full hour. So I'm not sure if people have any particular questions. There was a couple in there around health staff and what support is being given to health staff around assessing capacity and best interest, particularly because under the Home First system, an awful lot of responsibility is being placed on ward staff to assess people's capacity or to identify where people may not have capacity to make their own decisions. We're working with BCP to put some training in place, and with the leads in the acute hospitals and with Dorset Healthcare, there's a short recorded training video for people to look at. And we're also looking to do one of these sorts of webinars for sisters and matrons to be able to go through issues around assessing capacity, and particularly in the context of relatively quick assessments of people on the ward, and then people who may be moving either home or an interim bed for the fuller assessment of their future needs to take place. So we are trying to support ward staff. And I think that some ward staff are finding that quite a difficult transition, where hospital social work teams aren't able to go in and do some of the work that you were doing before. And so much more of the responsibility is landing on the desks of ward staff. I think it's very difficult. I think somebody's talked about how uncomfortable they feel placing someone into an interim placement when they don't understand fully that they won't see their families. I think that's part of the best interest decision, because the impact that will have on somebody, particularly at the moment with COVID isolation and the need probably to isolate for 14 days when they move, even if they've got a negative test, that needs to be taken into consideration when making that best interest decision. And it might be, in those borderline cases, that might be the tipping point between whether that interim place is appropriate and necessary, or whether actually the distress it would cause would be too great, and that swings it back into an alternative, probably going home with a package of support that may not be ideal. It may not be as good as we would like it to be, but we need to take the distress that we feel that somebody would experience being separated from their families, particularly at the moment where that's likely to be restricted. And certainly over the next month, it's going to be, I suspect it may well be longer than that before care homes feel confident enough to be able to open up their homes in the way that they may have done previously. Just looking at other things that are going forward.
Someone said, I find it quite common for other professionals such as police, GPs, not all, to often say that a person needs residential care without considering other options. I
absolutely think that it needs the person's wishes and feelings, and I think that's where we would start off with. And the advice that I would give anybody, but I would particularly be giving the hospitals at the moment, is to start that conversation early. So rather than waiting to the point where someone no longer needs to be in hospital, but having those discussions around what's happening with the patient, even if they lack capacity to make the decision, and even if it's clear that they lack capacity, but to involve them as much as possible in what's being discussed, and to try and figure out, either from them or from their families or other people, what their wishes and feelings are likely to be around the care and treatment that they would prefer, and then what sort of things are on offer. So absolutely, it's not just a social work or a social care responsibility. We can support where we can. I think we will support where we can. But ultimately, it's going to be the people making the capacity assessment that will need to have shown that they've included the person in that process. And where a best interest decision is made, the starting point will always be where what the person's wishes and feelings are. Now, they won't be determinative, and it might well be that I desperately wish to go home, but actually it really isn't. And the general opinion and agreement is it really isn't possible. And what I want isn't deliverable. And the consequences to me lacking capacity are beyond that, to which I can understand and consider in my decision making. So it may not be where I end up, but the starting point should always be where my wishes and feelings are. Okay. And that applies to whoever's doing that.
I've got two more questions hopefully we can squeeze in. Kay has said, it would be useful to have an idea of what is relevant and not relevant in assessing capacity around accommodation.
And I think that's something we covered earlier on. I think that's the list that the court case gave, is looking at the sorts of factors that are likely to be relevant in any consideration of accommodation and about care. And I said that the balance between the various factors may vary depending on the individual set of circumstances, but in general, that sort of checklist, if you like, is quite, I think, is quite helpful starting point when making an assessment of somebody's capacity around their capacity about their accommodation. And the second bit was around the ability to decide around their care. And I think, again, having that sort of checklist, at least in my head, when I start doing an assessment, there may be other things that get added in because of the particular factors. There may be some things that are slightly less important because of the circumstances of the case. But those general points are going to be the ones that are going to start me off on my assessment of person's capacity.
Okay, this is a good one for you. Their biggest challenge faced at the moment, this is from Link Worker, is that clients are deemed to have mental capacity but don't have day-to-day capacity. Any thoughts? Trick question.
I suspect that might well be looking at people who can almost talk the talk but not walk the walk. So that if you have a conversation with someone, they can tell me how they'll manage, they can tell me about what needs doing and understand what's going on, but the evidence would suggest that they can't put that into practice. Something that's sometimes called executive capacity. I don't like the term because I think there is only one capacity test, if you like. The Mental Capacity Act doesn't have a separate test, but certainly I think that some of the questioning, some of the exploration of somebody's capacity needs to go further than just, can they tell me the right answers? It needs to be tested out with, well, that's fine, and that's a good starting point, but if the evidence suggests that that's not what happens, what's their explanation for that? If somebody doesn't understand the fact that they say that this happens, but actually it doesn't. They say that they need this, but then when it comes to actually putting it into practice, they aren't able to do that. And I guess it is part of the capacity assessment, is not just that on the spot chat with somebody, and can they, if they're verbally intact and quite articulate, sometimes people are able to express things which the evidence suggests that they're not able to put into practice. And certainly I think that a capacity assessment would have to investigate why there's a gap between what they're saying and what they're doing. I'm not sure if that answers the question, but that would be in some ways. I think that's why the preparation for a capacity assessment is important, because knowing what was happening before what the concerns have been around somebody. So if someone tells me that they're perfectly happy going home because they're able to cook for themselves and they do their own shopping, and their daughter comes to help them out with things twice a week, and so therefore they're perfectly happy going home and they don't need to go to residential care, then the fact that I know that their daughter hasn't been round in 6 months, that they almost burnt the flat down because they weren't able to remember about turning the cooker off, and they were malnourished when they came into hospital because they hadn't done any shopping and they weren't able to feed themselves, that would have to be part of my capacity assessment, to have that discussion with them, that yes, they're saying that these things happen, but the evidence would suggest that that didn't happen. So what's their explanation for that? How do they account for the fact that there's a gap between what they're saying is going on and what is actually happening? Just some information about further dates. We haven't got a webinar in December, although there is a special learning festival of learning event later on this month, looking at the positive examples of good practice that we've discovered during COVID, and hanging some more MCA and DOL stuff onto the positive examples that we found. But there are 3 more at the start of next year, so the dates are there. We haven't got subjects for those, so if there are any particular aspects of the Mental Capacity Act that you are interested in us covering, please let us know. That's part of what the feedback is for. There's a list of useful resources that you're probably familiar with, but we put up again so that you can access those. You will also be able to find previous recordings. So if you've missed any of our previous monthly sessions and you want to have a look at those at any time, they're accessible on that site, and there's a link there. That's all I wanted to say. I just wanted to say thank you to Sandy for her contribution, and thank you for sticking with us and listening to what we've got to say. Please do feedback on how it's gone. If we got the tone wrong, if we didn't deliver what you wanted, let us know. If there were bits of it that you liked, let us know that as well. We will try and incorporate your comments into our next sessions. And as I said before, if you've got a subject or an issue that you think would be useful for us to cover, let us know, and we'll do our best to incorporate that. Yeah. Thank you very much, and I just need to say goodbye, and we will see you again next time.